Hi, everyone. Thank you for attending today's session, Employment Law During a Pandemic. Today's session will run about 45 minutes with time at the end to answer questions. Please post any questions in the chat box. Any unanswered questions will be answered offline after today's session. We have received a tremendous response to this webinar, and we are hosting a very large audience today. If you experience technical difficulties, we suggest you exit the meeting and re-enter it using the link provided in the email. Rest assured that LexisNexis will distribute a recording of today's session in a follow-up email. Now we will meet today's presenter. I am your moderator for today, Monica Sorensen. I am the print marketing manager here at LexisNexis Canada. Sean J. O'Donnell is an advocate with extensive experience in employment, human rights, and civil litigation. He is the founder and principal of SJO Legal Professional Corporation based in Toronto. Sean combines his passion for employment and human rights law with his Bay Street litigation experience to provide advice and advocacy to both employers and employees. He has represented clients at various Ontario tribunals and federal courts across Canada and has litigated matters at all court levels in Ontario, as well as the Supreme Court of Newfoundland and Labrador and the Supreme Court of Canada. He is also the author of Employment Law During a Pandemic, published by LexisNexis in January 2022. I will now turn it over to Sean.
Thank you very much, Monica. Thanks for the introduction and thanks for hosting this webinar today. So let's get started. So the main issues that we're going to be tackling today are wrongful dismissal and constructive dismissal, mitigation of damages, human rights issues, occupational health and safety issues, and vaccination issues. So let's talk a little moment about wrongful dismissal. So wrongful dismissal occurs when an employee is dismissed from their employment and they are not given the correct amount of either working notice or reasonable notice. And there are essentially two things that an employee can claim. They can claim notice and severance under the Employment Standards Act, and they can also claim common law reasonable notice if there's no written employment contract or if there is no enforceable termination clause outlined in their employment contract. And one of the issues that has become a very hot topic, especially in the case law, is the effect of the pandemic on reasonable notice and whether this will extend what would be the normal reasonable notice period. So one of the first cases I'd like to look at is it's actually a case from Alberta. It's the Hunsley and Canadian Energy Services decision from 2020. So the employee in that case was dismissed without cause on September 24th of 2019 and was dismissed due to financial challenges in the oil and gas industry, which was then exacerbated by the pandemic. And the court held in this particular case that economic conditions can be considered under the availability of similar employment factor in terms of calculating common law reasonable notice. And as you can see, the judge in this case stated that adverse economic conditions tend to increase the notice period because they usually contribute directly to the estimated time required to find replacement employment. However, the court in this case did go to some lengths to state that this is simply one factor in calculating common law reasonable notice and cannot be afforded disproportionate effect. But the key thing to remember in terms of the pandemic and how it affects common law reasonable notice is that the important issue is what is the economic state at the time of dismissal, not what happens after dismissal. Another case that came out in 2021 is the Yee and Hudson's Bay case, which is from Ontario. In this case, the employee was terminated in August of 2019. And this employee made approximately 90 job applications without success and claimed as part of the litigation that the pandemic increased their difficulty in obtaining comparable employment. So the court considered that issue and distinguished between dismissals that occurred before the pandemic and during the pandemic, and relied on an Ontario Court of Appeal decision from 2015, which was the Holland and Hostopia decision, where the court stated in that decision that notice is to be determined by the circumstances existing at the time of termination and not by the amount of time it takes the employee to find employment. There's also a quote from Justice Dye in the Yee decision, where he said that it seems clear terminations occurring before the pandemic and its effect on employment opportunities should not attract the same consideration as termination after the beginning of the pandemic and its negative effect on finding comparable employment. Another decision from Ontario from 2021 was the Craft and Firepower decision. In this case, the employee was unfortunately terminated in the second week of March 2020, which was mere days before Ontario declared a state of emergency. And the court observed in that case that on the day the employee was dismissed, because of the pandemic, the economy was already shutting down and remained closed during the employee's inevitably prolonged job search. So the court found this to be a key factor when determining the notice period and stated that there's evidence that the pandemic impacted the plaintiff's ability to secure new employment. And in light of that evidence, the employee deserved an above average notice period, which was 10 months for this particular employee. Another decision from Ontario from 2021 is the Irotakis decision. And as you can see from the slide, the court stated that uncertainties in the job market at the time of termination served to tilt the period of reasonable notice away from what would normally be a fairly short period of notice, given that the employee in this case had been employed for a short period of time. Yet another decision from Ontario is the Russell and Brick Warehouse decision from 2021. In which the court considered the issue of extraordinary circumstances and whether that would militate in favor of a notice period above 24 months, which is an unofficial cap. And this unofficial cap comes from the Daw and Equitable Life decision in 2019. So the court actually declined to extend the notice period on the basis that the pandemic was an extraordinary circumstance in this case. So there are a few conclusions that we can draw from the case law that we've seen so far. First of all, the pandemic tends to justify a longer notice period, but only where the dismissal occurs after the economic effects of the pandemic first arose. Also, this factor should not be given undue weight. And as I just mentioned, the pandemic is not considered to be an extraordinary circumstance justifying a notice period in excess of 24 months. So moving on from wrongful dismissal into the area of constructive dismissal. So what is a constructive dismissal? Essentially, constructive dismissal is a fundamental and unilateral change to the employment relationship, fundamental change made by the employer. So there are two branches of constructive dismissal, and these two branches come from a Supreme Court of Canada decision of 2015, which was the Potter decision. The first branch of constructive dismissal is a single unilateral act breaching an essential term of the employment contract. And one of the main single unilateral acts we've been seeing throughout the pandemic is a significant reduction in employees' compensation because of the pandemic, or in some cases, a complete reduction in compensation where employees are laid off for a period of time. The second branch of the constructive dismissal test is where an employer evinces an intention to no longer be bound by the employment contract, typically through a series of small changes that occur over a period of time. So what can an employee do when they're faced with a constructive dismissal? Well, we have some guidance on that issue from the Ontario Court of Appeal from the Wrongful decision in 2008. So the three options that an employee has is, first of all, they can accept the change, in which case their employment continues under new terms. They can also reject the change, allege constructive dismissal, and sue for damages if the employer treats the change as being in effect. Or the third option is to reject the change, place the ball in the employer's court, and the employer can basically do one of two things. The employer can terminate the employee and offer re-employment on new terms, Or if the employee is not fired and continues to work, the employee can insist on adherence to the original terms of their employment. So as I mentioned briefly, in terms of constructive dismissal as it relates to the pandemic, one of the biggest issues is temporary layoffs and whether or not they are constructive dismissals. So a temporary layoff is a constructive dismissal where there is no layoff provision in the employment agreement, or 2, where there is no written agreement to the layoff in advance, or 3, where the time period of the layoff is more than the time period set out in section 56 sub 2 of the Employment Standards Act. This issue was further complicated by the issuance of the Infectious Disease Emergency Leave Regulation, which was issued under the Employment Standards Act in May of 2020 and was made retroactive to March 1 of 2020. And this regulation has been extended on several occasions and currently is set to expire on July 31st of this year. So an infectious disease emergency leave is essentially an unpaid job protected leave. And this is for non-unionized employees who have been temporarily laid off due to the pandemic, or who otherwise have had their hours of work or wages reduced or eliminated because of the pandemic. And the idea being that these type of layoffs would not be considered to be constructive dismissals. And temporary layoffs that extend beyond the time periods provided for in the Employment Standards Act are not to be deemed terminations while the regulation is in effect. And also any claims that were brought to the Ministry of Labour alleging constructive dismissal due to the temporary reduction in wages or elimination of wages were automatically dismissed under the regulation. But the issue that we've been grappling with for quite a while now is whether or not these type of temporary layoffs would be considered to be common law constructive dismissals. So there are a few decisions on this. The first one was the Coutinho decision from 2021. So in this particular case, the employee was placed on an infectious disease emergency leave pursuant to the regulation. The employee sued, and surprisingly, the employer moved for summary judgment on the basis that the regulation barred her common law right to damages for constructive dismissal. So Justice Broad, in deciding on the motion, held that the common law right to access civil remedies following a constructive dismissal was not impeded as a result of the regulation. And he focused on section 8.1 of the Employment Standards Act, which states that no civil remedy of an employee against his or her employer is affected by the act. And his full quote is there on the slide as well. So in his view, the scope of section 7, which deemed a temporary layoff for reasons related to the pandemic to not constitute a constructive dismissal, was constrained by section 8.1 of the ESA. And he also stated that it's not possible to reconcile the interpretation of the regulation with the section of the statute which unequivocally provides that an employee's civil remedy against his or her employee shall not be affected by any provision of the Act. So there have been some other decisions on this, and they're conflicting decisions, or there is at least one conflicting decision, which was the Taylor and Hanley Hospitality decision, which was issued about 1 month after Coutinho. And in this case, the employee was temporarily laid off from a Tim Hortons franchise in March of 2020 because of the pandemic, was actually later recalled to work in September of 2020. This employee sued their employer for constructive dismissal and argued that the regulation did not displace her common law rights. And it was Justice Ferguson who decided this decision, and it was in direct contrast to Coutinho. Justice Ferguson stated that the analysis in Coutinho was wrong in law, and the court was not bound by it. It was her view that deeming a temporary layoff as a constructive dismissal at common law, despite the regulation, offends the rules of statutory interpretation, essentially because it would render the regulation meaningless. And she came to this conclusion by relying on the principles of statutory interpretation, which were outlined in an Ontario Court of Appeal decision from 2011, which was the Elsgood decision. Interestingly, a few days after the Taylor decision, there was another decision on this very issue, which was the Fogelman decision. And this decision followed Coutinho in finding that an employee can sue for constructive dismissal after being temporarily laid off under the regulation. So we don't really have a clear answer on this issue, unfortunately, although the Taylor decision, the appeal in that decision is being heard by the Court of Appeal on April 1st of this year. So hopefully we'll have some clarity on this going forward in the next few months. Moving on from constructive dismissal to the issue of mitigation of damages and whether or not the courts will take the pandemic into account when they're assessing an employee's mitigation efforts or efforts to find new employment after they have been dismissed. And the answer to this is likely yes. The key factor on this issue is the availability of similar employment, which directly correlates with an employee's duty to find similar employment. So there has been a BC decision on this issue, which is the Mohammed decision from 2020, where the court found that economic factors arising post-termination, such as those from the pandemic, can be relevant to mitigation if they impact the availability of equivalent employment. And moving on from that issue is the issue of whether or not EI benefits, CERB and CRB are to be considered as mitigation income. So mitigation income would normally be deducted from whatever an employer owes to an employee as part of the common law reasonable notice. The starting point for this is the Break decision from 2017 at the Ontario Court of Appeal, where Justice Belize stated that the law is clear. EI benefits are not to be deducted from damages awarded for wrongful dismissal. However, when a dismissed employee receives compensation from their employer for wrongful or constructive dismissal, they're generally required to pay those EI benefits back to Service Canada. And those would be EI benefits that they received during the reasonable notice period. However, interestingly, what the federal government did in 2020 was they issued interim order number 8, which was an amendment to the Employment Insurance Act. And the effect of this was to render any notice of termination or severance entitlements paid to an employee after September 27, 2020 as not earnings for the purposes of assessing entitlement to EI. And this means that an employee, if they're terminated between September 27, 2020 and September 25 of 2021, they were essentially allowed to double dip by receiving both a severance package and also availing of EI benefits. And although this order did expire on September 25 of last year. And then moving on from EI to CERB. So CERB is a little bit different. CERB was implemented to assist employees in coping with terminations due to the pandemic. In the very early days of the pandemic, from March 15 to September 26 of 2020. And most employees who were receiving CERB were automatically transitioned to EI after September 26 of 2020. So is CERB mitigation income, and therefore should it be deducted from what an employee would otherwise owe? So we return to the Iratakis decision for this, where the court stated that CERB payments cannot be deducted from wrongful dismissal damages because CERB was an ad hoc program and neither employer nor employee paid into the program, and employees cannot be said to have earned an entitlement over a period of time. It's also a decision from BC, which is the Hogan decision, also stating that CERB is not mitigation income. And a decision from Nova Scotia, similarly, the Slater and Halifax decision, where the court stated again that CERB is not to be considered as mitigation income. Moving on from that issue to the issue of human rights, and just from the outset, I'd like to point out what the sources of human rights legislation are in Canada. So for Ontario in particular, the important statute is the Ontario Human Rights Code. And in the federal context, so for employees that are federally regulated, it's the Canadian Human Rights Act. And the function of both of these acts is to is to prohibit actions that discriminate against individuals based on a protected ground in a protected societal area. And for our purposes today, we're talking about employment. So what are some of the important human rights issues related to the pandemic? So first of all, one of the most important issues is going to be discrimination on the basis of a disability. So both the code and the Act state that an employer cannot discriminate against an employee on the basis of their disability, either under the code or the Act. And a couple of important issues I'd like to highlight here. First being infectious diseases. So employees who contract an infectious disease and experience any degree of physical disability or infirmity caused by the illness are protected by the code. Also, interestingly, the Ontario Human Rights Commission issued a policy statement quite early on March 13 of 2020, where they confirmed that the code ground of disability is engaged in relation to COVID-19, as it covers medical conditions or perceived medical conditions that carry significant social stigma. One of the other important issues in this sphere is mental health disabilities. So I think it's reasonable for employers to expect that at least some of their employees will experience mental health challenges because of the pandemic. And it's worth pointing out that employees who are diagnosed with a mental health disability during the pandemic or at any time must be accommodated. One of the other important areas in which we may see some discrimination cases arising are based on race, color, national origin, ethnic origin, place of origin, ancestry, or citizenship. So the code lists all of these areas as grounds upon which one cannot discriminate. And discrimination claims can arise where employees of a particular race are targeted or stereotyped by their employer. And as an example, where an employee is asked detailed questions relating to their travel history and their family's travel history, but other employees of a different race or different national origin are not subjected to this type of interrogation. One of the other concerns as well in this area is that employees with East Asian backgrounds may face discrimination based on xenophobic descriptions of COVID-19. And one of the other issues one of the areas in which we're seeing a lot of concerns is family status, discrimination on the basis of family status. So both the code and the Act enumerate family status and marital status as grounds upon which an employer cannot discriminate. While an employee may not be directly vulnerable to COVID-19, they may have additional obligations due to the vulnerability of a family member. And employers should allow employees to take reasonable leaves of absence to care for family members who have a disability, who are ill or who are elderly. One of the other issues for employers as well is that they should be attentive to the needs of employees who are parents to babies, toddlers, or school-aged children, particularly in light of school closures. So accommodations in this area could include providing for alternative work locations or providing flexible scheduling, which a lot of employers have been doing throughout the pandemic. And just to talk about accommodation generally. So employers, they owe a duty to their employees to accommodate. This arises mostly in the context of disability, but it can also arise in other areas such as family status. So looking at disability as a starting point, the duty to accommodate is triggered here where an employee notifies their employer of the existence of a disability that interferes with their duties and requests accommodation. So there are two components to the duty to accommodate. First of all, there's a procedural component where an employer is expected to obtain information and assess potential accommodations. And then the second component is a substantial component, which is essentially offering whatever the appropriate accommodation may be. But the duty to accommodate is not absolute, and there is a limit, which is the employer is expected to accommodate to the point of undue hardship. And undue hardship is assessed on essentially three different factors. The first being, is the cost of the accommodation prohibitive? Secondly, are there any safety concerns? And then third, Will there be excessive disruption to the workplace as a result of the accommodation? And one of the main forms of accommodation that we've been seeing during the pandemic is the ability to allow employees to work remotely. There are several advantages to this for both employees and employers. So for example, for employees, they can customize their work environment. They can eliminate commuting time and costs, complete household tasks or exercise during breaks. They're free from office distractions, and in theory, there's an increase in productivity. The advantages for employers are quite obvious: reduced office costs, also access to a wider pool of skilled employees who may not have ordinarily worked in the physical workplace, and also an increase in productivity. There are some disadvantages as well, those being a lack of social interaction and personal contact. And one of the other issues is that for an employer is that direct supervision is quite a bit more difficult where employees are working remotely. It is worth remembering, however, that employees are not required to accommodate employees who simply prefer to work from home and who refuse to return to the workplace as the pandemic subsides. Moving on from human rights issues and into occupational health and safety issues. So there's a general duty that an employer has under the Occupational Health and Safety Act in Ontario to take reasonable precautions to protect the health and safety of its workers. In the context of the pandemic, employers can expect that workers to exercise their right to refuse unsafe work based on what they perceive as inadequate protections. And just looking at a little bit more closely at work refusals. So as I've said, workers are entitled to refuse work where they have reason to believe that, for example, the physical condition of their workplace or any equipment that they use is likely to endanger them. And this is quite restricted for certain workers. So firefighters, police officers, and certain healthcare workers do not have quite the same ability to refuse work. And where a claim or a work refusal has arisen, employers have an obligation to do several things. So first of all, they must internally investigate the situation. They must record the circumstances of the refusal and the investigation. And they must also ensure that any necessary action is taken to remedy the danger. And if the worker continues to refuse work after all of these steps are taken, a government health and safety officer must be notified. So just some general advice for employers on occupational health and safety issues as they relate to the pandemic. There's certain things that employers can do, such as restricting individuals from the workplace based on the official criteria for recommended or required self-isolation, including people who are returning from travels outside of Canada. Employers can also require employees who have COVID symptoms to stay at home, contact public health authorities, and follow their directions. Employers can also encourage social distancing to reduce transmission, which may involve facilitating remote work arrangements and rearranging the workplace for other workers if practical to do so. And then finally, an employer can promote good hygiene practices, including frequent hand washing, avoiding the touching of one's face with unwashed hands, coughing or sneezing into one's elbow, and ensuring the regular cleaning of high-touch surfaces in the workplace. And then moving on to the final issue, which is vaccination issues, which is possibly the hottest issue in employment law and elsewhere at the moment. So the main question I've been asked by both employer clients and employee clients is, can employers mandate employees to be vaccinated against COVID-19? So the answer to this, like so many answers in employment law, is nuanced, and it requires an evaluation of each employment arrangement. And there are two ways, or there are two sort of sources of these mandated vaccination policies. So the first is a statutory mandate. And in this case, the responsibility is shifted from the employer to the government as to whether or not the policy is reasonable. So one of the examples of a statutory mandate comes from Ontario, where Ontario mandated immunization policies for long-term care homes in May of 2021. And in those particular workplaces, employees were expected to do one of the following. First, provide proof of vaccination. Second, provide a documented medical reason for not being vaccinated. Or three, participate in an educational program about the benefits of vaccination and the risks of not being vaccinated. And also in the federal sphere, in August of 2021, the federal government announced that it intended to make COVID vaccines mandatory for federally regulated employees. I don't think the actual regulation or the legislation is in effect at the moment. There is talk of bringing this regulation or legislation into effect in early 2022, but I don't believe it's being taken effect yet. And then moving on from statutory mandates, so this is going to apply to the vast majority of employers in Ontario, so non-statutory mandates, where employers decide for themselves as to whether a vaccination policy or a mandatory vaccination policy should be put in place. So there are several factors to consider, and before we get into the specific case law. So first of all, is the employee in question a potential or an existing employee? So potential employees should obviously be made aware of the vaccination policy before they accept employment. It's a little bit more complicated for existing employees because they obviously did not have an opportunity to accept a vaccination policy at the outset of their employment. And without cause dismissals based on refusals to be vaccinated can be very costly for employers. One of the other factors to consider is the employer's duty to maintain a safe and healthy workplace. So this takes us back to my discussion about the Occupational Health and Safety Act and the obligation of an employer to maintain a safe and healthy workplace. So policies and procedures that an employer can implement include testing requirements, social distancing, and sanitization. And generally speaking, vaccination policies are likely to be upheld if they are reasonable, which we will see from some of the cases I'll talk about in a moment. Another important factor to consider is the nature of the specific workplace. So it can be difficult to justify imposing a requirement to be vaccinated on remote workers because the health and safety of the workplace is obviously not an issue if the employees are not physically in the workplace. And then for some workplaces, physical distancing and masking and those type of regulations may be sufficient where the employees are not in close quarters or they're working outside. But there are some workplaces where vaccination may be considered to be essential, in my opinion, and these are workplaces with healthcare workers, with teachers, and in retail, where there's a lot of interaction with the public. A couple of other factors as well, starting with the duty to accommodate. So it's worth pointing out that employers cannot impose mandatory vaccination on an employee who has a medical condition or a disease that makes it more dangerous for them to receive a vaccine, or an employee has a severe allergy to or is taking a medication that will react with the vaccine. So employers cannot impose mandatory vaccination on employees who are also cannot impose mandatory vaccination on employees who are a member of a religion that objects to vaccines. And this takes us back to actually a 2011 decision of the Ontario Human Rights Tribunal. This is the Lambton decision. This was actually a decision about an employee who refused to take an influenza vaccine. So in that case, the tribunal found that the employee's general objection to vaccinations did not amount to a creed or a religion under the code, which was not surprising. And then the last important factor to consider is an employee's right to privacy. So there has to be a balance between the right to privacy with the obligation to provide a safe and healthy workplace. And the legislation that we look at in Ontario in particular is PIPEDA. So under PIPEDA, in order to seek vaccination status, there must be a need to do so, and that must be tied to a legitimate workplace purpose. There must be no less intrusive way to achieve that purpose. And it should probably go without saying that the vaccination status of employees should not be disclosed to customers or clients, except with the express consent of those employees. So just getting into some of the decisions now, which reflect the factors that I've already discussed. It's worth pointing out from the beginning that we only have arbitration decisions so far. So these are decisions in a unionized workplace context, but they do provide some good guidance for all employers, even in a non-unionized context. I should also say at the beginning that these decisions are highly fact and context specific. So one of the first decisions, which was from November of 2021, was the United Food and Commercial Workers Union and Paragon decision. So in this particular decision, the mandatory vaccination policy was upheld. And it's worth looking at the specific context of the workplace in this case. So Paragon employs thousands of security guards, and they operate at a majority of workplaces that have their own mandatory vaccination policies. And the collective agreement in this case states that if a security guard was stationed at a third-party site with a mandatory vaccination policy, then that security guard must be vaccinated or reassigned to a different work site. So Paragon implemented its own mandatory vaccination policy, and the union grieved this policy. And the decision, as I've said, from the arbitrator was that the vaccination policy was upheld. And according to the arbitrator, he held that the policy was unreasonable, enforceable, and compliant with the Occupational Health and Safety Act and also the code. He also stated that Paragon had an obligation under the Occupational Health and Safety Act to take every precaution reasonable in the circumstances for the protection of its workers, and that the personal subjective perceptions of employees to be exempted from vaccinations cannot override and displace the available scientific considerations. One of the other important facts in this case as well was that the mandatory vaccination policy was in alignment with the collective agreement. And then a few days later, we saw another decision in the arbitration context. So this was the Ontario Power Generation and Power Workers Union decision. So looking at the context of this workplace and this vaccination issue, it essentially related to gyms that the OPG had on site that could be used by employees. So in September of 2021, the OPG reopened their gyms and allowed unvaccinated employees to use the gyms as long as they provided a negative test within 48 hours of usage. They later amended their policy, however, to prohibit unvaccinated employees from using the gyms at all. And the union grieved this decision. So the decision in this case was that the policy was upheld, and the arbitrator stated that it's a matter of public record that gyms are high-risk areas for transmission because of high-touch surfaces, increased potential for close contact, and a greater range of respiratory droplets due to heavy breathing. And the arbitrator also considered the fact that the Ontario government had mandated that public gym users are required to be vaccinated. And then moving on from this decision, around the same time in November of 2021, there was a decision where the arbitrator held that the mandatory vaccination policy was unreasonable and therefore unenforceable. This was the Electrical Safety Authority decision. So again, looking at the context of the workplace and the policy, before implementing the mandatory vaccination policy, the Electrical Safety Authority already had a voluntary vaccination disclosure policy, which required unvaccinated individuals to submit to regular COVID-19 testing. So the decision in this case was that the arbitrator held that the policy was unreasonable and could not be justified. And the reason for that is that he considered that most of the Electrical Safety Authority's employees were still working from home, and therefore there was no significant risk of transmission to fellow workers. The arbitrator also talked again about the importance of context, the context of the workplace, and stated that where the risk to health and safety is great, an employer may encroach upon employee rights as long as they take a tailored approach. And looking at some of the factual findings in this case, the arbitrator found that, first of all, there had been no outbreaks in the workplace. Second, the Electrical Safety Authority did not face any difficulty in protecting the workplace using the previous policy. And third, there was no evidence that the previous policy led to a substantial interference with its business. Another more recent decision in this area is the Bunge-Hamilton Canada decision. So again, looking at the specific context of the workplace, employees who worked for Bunge-Hamilton were sometimes required to work at either of two different work sites. So one of those sites was leased from the Hamilton-Oshawa Port Authority, and the Port Authority itself had issued a mandatory vaccination policy on November 1 of 2021, making it clear that anybody who was on their land had to be vaccinated. So about a week after this, Bunge issued its own vaccination policy so that they would be in compliance with the Port Authority's policy. And under Bunge's policy, any employee who was not fully vaccinated by January 24th of this year would not be allowed on site and would be placed on an unpaid leave. The union also grieved this policy. And the decision that was issued was that the arbitrator found the policy was reasonable, did not violate any privacy rights, and was a reasonable exercise of management's right to issue workplace policies. Just looking again at some of the factual findings in this case, because I think this will give some good guidance to employers who are, and their counsel who are drafting policies, mandatory vaccination policies. So one of the first factual findings was by the arbitrator was that if Bunge had not implemented the policy, it would not have been able to properly operate its business because of their lease obligations with the Port Authority. Second, the arbitrator found that unvaccinated employees create a known public safety and health risk for both the vaccinated and unvaccinated. Third, unvaccinated employees are able to work remotely. Fourth, the policy does not provide for automatic disciplinary suspension or termination. It merely stated that unvaccinated employees would be placed on an unpaid leave. And then fifth, the policy allowing for testing as an alternative would not have been reasonable, as it would have resulted in a breach of the Port Authority's requirements. And the arbitrator, in looking at this case, distinguished it from the Electrical Safety Association decision, as the context in that particular case was meaningfully different, according to the arbitrator, in that many of the employees affected were able to work effectively by remote work and in compliance with the Port Authority's policy without causing significant impediments to the employer's operations. So as you can see, we've had a number of decisions on this, but unfortunately still no court decisions. Hopefully that will happen over the next few months, and we'll have some more clarity on vaccination issues. So that brings me to the end of my part of the presentation, and I'd be happy to answer any questions that anybody has.
Thank you, Sean. We actually had quite a few people ask questions when they registered, so
Okay.
I will just go through the list with you. So the first question is there an increase in reasonable notice due to the pandemic?
Yeah, so this takes us back to the early slides where I was talking about wrongful dismissal and the effect of COVID on notice cases. So what we've been seeing so far is that, yes, there does tend to be an increase in notice periods, but again, it's important to look at when the employee was terminated. So if they've been dismissed a significant period of time before the pandemic, then it's less of a factor, because the key issue is what are the circumstances at the time of termination. So it's a little bit different than somebody who's terminated during the pandemic, because obviously the economic effects are being felt at that time, and that is likely to increase the notice period. or at least have it at the top end of the range of what would normally be awarded for an employee of a particular age, length of service, their character of employment as well.
Okay, great. The next question. Considering that notice of termination is intended to address the time it takes to find a comparable job, if a dismissed employee mitigates her damages by finding another comparable job within a month or 3 months of termination, is the employee entitled to more notice than it took to find the new job?
Yeah, so I mean, it's worth pointing out that an employee can always be entitled to more notice than the time it takes them to find a new job. And I'll give you an example. So if for example, an employee of a particular age and length of service was entitled to a notice period of, let's say, 12 months. If that employee obtains a new job within 3 months, the employees they're entitled to the 3 months, but they're also entitled to the difference between what they were earning with their previous employer and the new employer for that additional 9 months, which comprises all of the common law reasonable notice period.
Great. Okay, next question. Can an employer make it compulsory for employees to return to work in the office on a hybrid or regular full-time schedule when remote work poses no extra cost, performance, or any other issues?
Yeah, so I mean, this is a question I've been getting a lot from my own clients. So, I mean, an employer could insist that employees return physically to the workplace, but I would say that there's a decent argument that this would be potentially a constructive dismissal. The reason being that, let's say the employee has been working remotely for 2 years, or almost 2 years, because we're almost 2 years into the pandemic. If the employer chooses to bring the employees back to the office, essentially what they're doing is they're unilaterally changing a fundamental aspect of that employee's employment arrangements by forcing them to return to work. So I think it's decent grounds for a constructive dismissal argument, probably best for employees who want to take that route to attempt to negotiate some sort of severance package with their employer, because if they can't negotiate something, then they're faced with a tough decision as to whether they quit and sue their employer for constructive dismissal, while still having an obligation to mitigate their damages by looking for comparable work.
Okay, great. The next question. What are the likely consequences for an employer that terminates an employee's service where the employee had asked for exemption from vaccination based on the Human Rights Code, but the employer had overruled the request that the request does not meet ground requirement?
Okay, so I expect this to happen quite a bit. The likely consequences are that the employee may bring an application to, in Ontario, the Human Rights Tribunal, or in the federal context could bring an application to the Canadian Human Rights Commission, notwithstanding the fact that the employer did not accept their exemption. As to whether or not they would be successful in an application, but either before the commission or the tribunal would depend on the circumstances. It may be a difficult case to litigate, I would expect.
Okay, our next question. Will you be addressing any procedures for meeting clients? Do you have best practices around that?
Yeah, so this takes me back to some of the general factors that I raised in terms of health and safety and the Occupational Health and Safety Act. So, I mean, I think it's prudent to ensure that any clients coming into your office or any customers coming in are masked, notwithstanding any political persuasions of people out there. But I think it's prudent, whether or not those are mandated by the government, to have people be masked and be vaccinated if possible. A lot of what I'm doing in my own practice is I'm generally having meetings with clients through Zoom or through some other sort of video conferencing software. I think, over the past 2 years, I've probably had maybe 1 or 2 clients come into my office where it was really essential for them to do that. But generally speaking, most types of work can be conducted remotely. And there are procedures for legal practitioners as well, in terms of having documents, affidavits sworn by video conference, which I think is a good idea.
Okay, great. Our next question. An employer with a mandatory vaccination policy fires an employee for non-compliance. Employee seeks work elsewhere but has difficulty obtaining work because many other employers have mandatory vaccine policies. Does the employee still have a duty to mitigate damages, or is that duty lessened somehow?
So that's a good question. I would say that employees always have an obligation to mitigate their damages. So the way that mitigation of damages works in a litigation context is that the employer has a burden to prove that the employee did not appropriately attempt to find comparable employment. So it would be some good advice for employees, which is the advice I always give to employees, is to keep a very good written record of all of your job applications, including whether you had interviews with these prospective employers, and the reasons as to why you were rejected from employment. So if the reason for being rejected from employment with these prospective employers is because they also have a mandatory vaccination policy in effect, then the employee should certainly lead evidence about that. They still have an obligation to attempt to mitigate, but I think that judges, if these cases go to litigation, they will look at that. And I expect that they would not discount the common law reasonable notice based on a failure to obtain new employment because of that reason, because of the vaccination policies that are rife in most employers in Ontario.
We have lots of questions coming in about constructive dismissal. What are possible defenses to a claim of constructive dismissal? What about in cases where employees have been placed on leave for not being vaccinated in accordance with workplace vaccination policies?
So, I mean, I hope a lot of these questions are going to be answered by the appellate decision in the Taylor case, which is coming up in April. But from my perspective, I think that I don't think most employees cannot be fired for a cause for refusing to be vaccinated, unless you're in a high risk setting. I can see a good argument as to why cause exists for healthcare workers, for example, for teachers and for retail workers. But for a lot of employees, and I've seen this in particular with the City of Toronto vaccination policy. So what I find surprising about their policy, which is publicly available, is that it applies, it's a blanket application to all employees, including remote workers. And so what the City of Toronto has done with all of their employees who have refused to get vaccinated or disclose their vaccination status, even if they're remote workers, is to terminate them for just cause, which I don't think they're going to be successful in establishing just cause. I don't have any of those particular cases right now, but I know some of my colleagues in the plaintiff bar do. But as far as I know, there have been no decisions issued. But I think the likely answer is what I stated, that there's likely to be cause for healthcare workers, teachers, and retail workers, and for the vast majority of people, there will not be cause, and these employers will owe them severance packages.
So what about people returning from mat leave and that particular person is not vaccinated, but they've come back to a company now that has a vaccine policy. Can you expand a bit on that?
I mean, there are exemptions for medical reasons and also for religious reasons, but this touches more on medical reasons. I mean, I think somebody returning from a mat leave, that's a good question. So if there's some medical reason as to why they should not be vaccinated or cannot be vaccinated, that should be raised with the employer before returning to the workplace. I think it would be, I mean, I think it would be especially harsh to fire someone for cause who's returning from a maternity leave. I don't think that the employer would get much sympathy either in the courts or the Human Rights Tribunal or the Canadian Human Rights Commission. I think that's a tricky one. I'm not entirely sure what the answer would be, other than to say that that particular employer would not have much sympathy, because I mean, when somebody goes on a mat leave, it's also a job protected leave, so the employee on the mat leave is expected to be returned into their position when they return.
Okay, we have time for one more question.
Okay.
Could being unvaccinated be a factor in calculating reasonable notice, since most employers require it?
Well, I mean, I suppose it could be, and it's sort of similar to one of the questions that was already asked. So, I mean, I think what happens, or what will happen, is the courts will look at and perhaps even take judicial notice of the fact that there are many employers in Ontario who require their employees to be vaccinated. I expect that there will certainly be no discount because of a failure to obtain employment. But I mean, it's always prudent for an employee to show, this is why I was rejected from employment with this particular prospective employer. And employees will want to build up some written evidence of all of these job applications and the reasons as to why they were not accepted. I do have a feeling that the unvaccinated, I mean, first of all, it's going to be very difficult for a lot of unvaccinated individuals to find jobs. I think that the notice periods will be extended. It's just a question of how much. I don't expect anything significant, maybe an extra month or two. I think judges are, they're going to have to take notice of the fact that there are lots of employers out there who insist on vaccination.
Okay, great. Now we would like to say some closing remarks. The webinar's recording, presentation, and any unanswered question will be sent out today in a follow-up email after the session. I would like to thank Sean for taking time to speak to us today, as well as everyone who has attended. For anyone interested in purchasing a copy of Sean's book, Employment Law During a Pandemic, it is available on the LexisNexis eStore at lexisnexis.ca/store. Sean, would you like to say any closing words?
Yeah, thanks, Monica. I mean, I'd just like to thank LexisNexis again for hosting this webinar, for publishing my book as well, which was very exciting. And thank you to everybody who is attending today. These are some very hot issues, and it's a good time for me as an employment lawyer to be useful to employers and employees alike.